Greetings to everyone, and good afternoon or good morning, depending on your location. It is great to see so many attendees on the meeting today, and thank you for taking the time to join us. Thanks as well to our speaker today, Nikki McDavid, and to Chris and all the other staff with the Transportation Learning Network for their help in coordinating this meeting. I would also like to acknowledge and thank the Federal Motor Carrier Safety Administration for the grant funding that made our work and these webinars possible. For those who do not know me, my name is Brenda Lance, and I'm the Associate Director of the Upper Great Plains Transportation Institute at North Dakota State University, as well as the Program Director for our Commercial Vehicle Safety Center. We are excited to have you join us today. The webinar today is the first in a series of follow-up webinars from the Western Commercial Vehicle Safety and CDL Compliance Summit we held in Denver this past November that many of you attended. The topics for these webinars came from suggestions from the summit attendees, and we plan to hold them about once a month. Suggestions for topics for future webinars are always welcome. As we proceed with today's webinar, feel free to use the chat box to type in any questions as they come up. In addition, we will take questions and have discussion after the presentation as we have time. With that, it is my pleasure to introduce our speaker for today, Nikki McDavid. Nikki is the Chief of the Commercial Driver's License Division at the Federal Motor Carrier Safety Administration. She is responsible for improving highway safety by ensuring that drivers of large trucks and buses are qualified to operate those vehicles and by removing unsafe and unqualified drivers from the highways. Her office does this by developing, administering, and implementing policies, standards, procedures, and guidelines for the National CDL program. Nikki, I'll turn it over to you.
Thank you, Brenda. And as Brenda mentioned, my name is Nikki McDavid, and I am the Chief of the Commercial Driver's License Division, and I want to welcome everyone to today's webinar. Today, I'm going to provide an update on a few of FMCSA's programs and regulations. The agenda is listed here. I'm going to give you an overview of the Under 21 Military CDL Pilot Program, talk to you about a couple of our regulations, the Drug and Alcohol Clearing House, and entry-level driver training, and also the National Registry of Certified Medical Examiners, our diabetes final rule, a Federal Register notice that we issued regarding U.S. Custom Harvesters, and a little bit about our Employer Notification System initiative. So for our Under 21 Military CDL Pilot Program, I'm going to give you a high-level overview of that program. The Under 21 Pilot Program was required by Section 5404 of the FAST Act. And basically what that section did, it required the FMCSA to study the feasibility of allowing covered drivers to operate in interstate commerce. As part of that legislation, it requires the FMCSA to conduct the pilot program in consultation with a working group. And the working group is actually tasked with monitoring and evaluating the pilot program once it's done. The working group has to consist of representatives from the armed forces, the motor carrier industry. It has to consist of drivers, safety advocates, law enforcement, and our state driver's licensing agencies. After the pilot is completed, the FMCSA must submit a report to Congress describing the findings of the pilot. The report has to also include the recommendations of the working group, and we are required to actually submit that report to Congress within 1 year after the actual pilot ends. So on the previous slide, I talked about covered drivers, and the definition of a covered driver is presented here. The first two bullets are pretty straightforward. We will get most of our participants, in our opinion, from the National Guard and the Reserve. There are actually 7 military occupational series that are allowed to participate in the pilot. The persons qualified in these MOSs have been trained to operate heavy vehicles in the military. So, for example, we have the Army. We call them the 88 mics. The Army has a 6-week curriculum that has 32 hours of lecture and approximately 190 hours of actual driving experience. And the other branches that you see listed here, they have equivalent training. So these covered drivers actually come to the pilot program with extensive training. The last bullet here talks about the limitations. If you look in the legislation, it talks about the limitations that these drivers, that have been placed on these drivers. So one, they can't transport hazardous materials for passengers, and the vehicle configurations, they can only operate, a tractor trailer. They can't operate any doubles or triples. So those are the limitations that were placed on them as a result of the legislation. On July the 6th of last year, the FMCSA published the Federal Register notice that actually announced the pilot program. The publication coincided with the Secretary's press event that was held in Omaha, Nebraska. And if you go to our website, you will be able to find a copy of that Federal Register notice. All you do is go there and search under 21 pilot program, and it should pop up for you. If you look in the Federal Register notice, there's a list of participation standards for motor carriers. So, for example, in order for a motor carrier to participate, they have to have proper registration, they have to have proper authority, they have to have the minimal levels of financial responsibility, they can't be a high or moderate risk motor carrier. And these are some of the performance standards that are listed within the actual Federal Register notice. There are also participation standards for drivers. The qualifications are actually aligned with those in Section 383.51, and those are the disqualifications that are listed there. On the slide, we talk about, and in the Federal Register notice too, the FMCSA, in order for us to have a statistically valid sample, we're looking to sign up 70 motor carriers. These 70 motor carriers, we hope, will provide 200 drivers to each of the groups, the study group and the control group. So our next steps, we are preparing for a spring 2019 kickoff, which is right around the corner, but it all depends on how long it takes for the approval of the information collection requests to come back. The information collection request actually allows the agency to collect the data that it needs from motor carriers. We're talking about crashes, vehicle miles traveled, and other safety events. And we need that to, as I mentioned before, to review that data and make a determination about the future of the pilot program. Now, I can say that the information collection request is probably a little behind because of the shutdown, but hopefully, that document will be shaken loose soon. We are standing by to make the announcement for the kickoff. It will be done through our website, through social media, press releases, and other ways too. So once the pilot is announced, the motor carrier will be able to apply, and once they receive approval, they can start hiring the covered drivers to participate in the Under 21 pilot program. The motor carrier will be responsible for making sure that its drivers meet the qualification standards that are in the Federal Register notice. The FMCSA will verify that information. So we plan to verify the information that the motor carrier submits on the drivers, and we plan to verify all of the information that they submit. So to the carriers that are actually accepted into the pilot program, FMCSA is going to issue them a letter. Drivers that are part of the pilot will be required to show the letter to law enforcement in the event the driver is pulled over. We're going to make sure that law enforcement can validate a driver's participation in the pilot. And so during the Western Service Center Safety Summit, talked about this, and one thing I can say, the actual verification piece is already ready. We tested it, so all a law enforcement agent would have to do is either put in the motor carrier's USDOT number or the driver's license information, and it's going to come back with a result. And you will be able to verify if a motor carrier or a driver is actually participating in the pilot program. It works pretty snazzy, and we hope that that information will be useful to you as you do your job at the roadside. As you know, we've received a lot of interest for the pilot. We have a list of motor carriers that are who want to participate. We have constant contact with the military, and we have a lot of interest, and hopefully once we get the pilot up and running, we will have those 70 motor carriers, at least 70 motor carriers, and at least the 200 drivers that we need to have a statistically valid sample to review the data to make some kind of inference about the data that we receive. What does this mean to you? So if you're an SDLA, you could continue to do what you do today. For our law enforcement community, we want you to continue to do what you do today, but we ask that you verify that a driver is a part of the pilot, and all of that information, once it comes out, we'll make sure that we get that to you. Motor carriers, you know, if you want to participate, you'll have to apply to the pilot program, hire drivers, and submit that data. So after all is said and done, in a few months, we will be able to kick off the pilot program, and you may very well be driving beside a 18, 19, or 20-year-old driver who's engaged in interstate commerce. So what I want to do, I want to pause here, and Brenda, I would like to see if our participants have any questions.
Nikki, I'm not seeing any. This is Chris. I'm not seeing any questions come in.
So I take it I can continue.
Yes, ma'am.
Okay, thank you, Chris. So the next thing we're going to talk about is the Drug and Alcohol Clearing House rule. As you know, drivers with drug and alcohol violations are not allowed to operate a CMV without going through the required return to duty process. Section 32402 of MAP 21 requires the FMCSA to develop a drug and alcohol clearing house. And there are a lot of benefits of having a drug and alcohol clearing house. Aside from the ones that are listed here, the clearinghouse is going to close the loop on those drivers that test positive on a pre-employment drug test, and they leave that motor carrier who refuses to hire them. They get their system clean, and then they go down the street and test negative, and then that and then that motor carrier hires them. So it's going to close the loop on those drivers who go from motor carrier to motor carrier and try to get a job, although they tested positive on a drug and alcohol test. The final rule requires FMCSA regulated entities to report test results. And I will show you on a screen what we're talking about when we talk about FMCSA regulated entities. It's going to contain information about whether a driver has successfully completed the return to duty process. So not only is it going to include the positive test results, it's going to also alert motor carriers, FMCSA, if a driver has actually gone through the return to duty process. And as I mentioned all the time, you know, the clearinghouse requirements fall into two major categories, and they're reporting and querying, and to a lesser extent, the notification and the registration portion of the clearinghouse. So let me just go back. When we talk about the regulated entities, we're actually talking about employers, medical review officers, substance abuse professionals, and those third-party administrators. So in the previous slide, I talked about the reporting and querying. Employers will be required to query the clearinghouse for current and prospective employees' drug and alcohol violations. And so for current employees, they have to query the clearinghouse on an annual basis. For prospective employees, they will have to query the clearinghouse before hiring the driver. So this gets back to the the driver that may try to skip out on a motor carrier or motor carrier that has not hired a driver that has tested positive. So all of the information is going to be in the clearinghouse, so that driver that was not hired by the motor carrier, that information will be in the clearinghouse. So if he tries to go down the street to another motor carrier, it will show up in the clearinghouse. So that's where speaking of what I talk about, it's going to close the loop on that activity. The NTSB will be able to access the system. They'll get that information from FMCSA. And this last bullet here, the final rule, we're talking about the Drug and Alcohol Clearinghouse 1 rule. It did require SDLAs to actually query the clearinghouse. However, we'll get into this bullet a little later in the presentation. So we talked about the regular entities. Our employers, our third-party administrators, the MROs, they will be required to report drug and alcohol testing program violations to the actual clearinghouse. SAPs will be required to report the return to duty process and whether the driver has actually undergone the treatment plan that the substance abuse professional has prescribed for him or her. Each time information is actually added or removed from the clearinghouse, the FMCSA will notify the affected driver. So drivers are going to have to actually sign up for notification, sign up through a registration process, and I have a slide, this next slide, that's going to just give you a high-level concept of how it's all going to work. So here, just based on everything I've mentioned before, in the middle you have the Drug and Alcohol Clearinghouse. The reporting is going to go in through our medical review officers. They're the ones that are going to report those positive test results, right? The third-party administrators, the substance abuse professionals, they're going to report those return to duty completions. Employers' actual knowledge. And on the right side of the screen, we're talking about the queries. The motor carrier is going to query the clearinghouse to see if one of its prospective drivers or current drivers have violations within the clearinghouse. The SDLAs, this is here just because of the final rule, the Drug and Alcohol Clearinghouse rule, the first one, and this was just to show the intent of the rule where the SDLA will query the system. FMCSA is going to query the system to carry out our compliance and enforcement efforts. And at the bottom of the screen, you see the employer and the driver. And when you think about the medical review officer, the substance abuse professional, they're going to have to register with the clearinghouse, and the employer and the drivers are going to receive notification. Drivers are going to receive notification if there's information in the clearinghouse about him or her, and the employer will be notified if there's information in the clearinghouse about its drivers. So high-level concept of how information will be reported, how certain entities will query the system, and the fact that the employer and the driver will be notified of information that's in the system, and they also have to register.
Nikki, we do have a question here.
Sure.
And the question is, when do we expect the clearinghouse to be available for public access?
So, and when you say public access, are you a motor carrier? I just want to get clarification on that. Because if you're just talking about the public being able to go into the clearinghouse to get information about a driver that is tested positive, that information is not going to be available to the public. But if you're a motor carrier and you are asking because in your duties you have to, if you look at the rule, you are required to do these queries, then that's another question. So I would like to just get a little more information before I answer it.
Okay, fair enough. So the person who asked that question, James, if you could please respond back with, are you asking for just general public access or as a carrier for the carriers?
Okay, so the rule is effective in January of 2020. So based on the information that I have, and it's a little further on in the presentation, I do have a timeline, and we'll get into that. So I'm going to continue on, and then we'll get into the timeline, and then if he has any other questions, we could go from there. Fair enough? Okay, so AMVA, the American Association of Motor Vehicle Administrators, submitted a petition for reconsideration to the Federal Motor Carrier Safety Administration. Basically, AMVA asked us to remove the state driver licensing agencies from the clearinghouse process. They felt that it was a motor carrier / law enforcement requirement and that the SDLAs should not be included in that process, okay? Their petition also said, hey, FMCSA, you issued a final rule, but you did not spell out the actions that you would like this SDLAs to take once the clearinghouse is queried. So we responded to AMVA and we say, sorry, SDLAs, as part of the legislation, the SDLAs are included in the clearinghouse process. And two, yeah, you're right. We did not spell out the actions that the SDLA should take after the clearinghouse is queried. So we're going to accept your petition for reconsideration. We actually turn it into a petition for rulemaking. And we're currently working on the Drug and Alcohol Clearinghouse 2 rule. And the purpose of that rule is to spell out those actions that the SDLA must take after the clearinghouse is queried. So the next steps, and this really relates to our state driver's licensing agencies that are on the phone. Between now and 2020, we're going to continue to build the clearinghouse, and we're actually doing that now. And we're also drafting an NPRM, and that would be the Drug and Alcohol Clearinghouse 2 rule. And, if you have sat in on a CDL coordinators meeting or a CDL roundtable, you all already know this information. So we continue to get the question, will FMCSA require states to query the clearinghouse even though SDLAs aren't required to take action? And the short answer is no. States are not required to take any action to prepare for the January 2020 compliance date. But if you want to query the system, I believe there's be functionality for you to do so, but you're not required to do so.
Okay, Nikki, there's a couple questions here. The first one is, will CDL schools be included in the clearinghouse?
I'm not sure. Can they give me a little bit of background information?
I'm wondering, this is a question that followed up that last one as far as the access. So I'm assuming, will CDL schools have access to the clearinghouse?
Oh, no, not at this time. And there was no, when you look at the legislation is pretty clear about the, what the agency is required to use that information for. I know that CDL schools conduct drug and alcohol testing of their drivers, they're going to have to get that information directly from the MRO or the CTPA.
Okay, and then the next question is, after testing positive and it's reported to the clearinghouse, when will the SDLA withdraw the driving privilege?
Well, that will be covered in the second rule, and all of that will be spelled out. But as I'm going to show on the next few slides, as we all know, if a driver tests positive, they're not supposed to drive, regardless if the SDLA suspends the license, right? So there will be indicators that will be passed along to law enforcement that drivers are not supposed to be on the road, that a certain driver is not supposed to be on the road, right? And then the motor carrier has a responsibility to, once they receive that information, that they remove their driver from the safety-sensitive functions that are spelled out in Part 382 of our Federal Motor Carrier Safety Regulations. So I hope that answered your question.
Okay, thank you.
Okay, so I spoke about our law enforcement and making sure that we provide the information about drivers that have drug and alcohol clearinghouse violations to them at the roadside. So this is just a high-level schematic. This is how we see it working. It may change by the time everything is implemented, but our federal and state personnel will go into the portal, and I take it that once you get there, you'll go through Query Central, and you will, put in a driver's license number, and the clearinghouse in the middle is going to ping all of these different systems, and you're going to come back with the result, right? So if there's a driver in the clearinghouse that has a violation, information is going to come back to you, and I'm just going to show you on the next slide how that information may look in the future. We're still working out all of the specifics about the messaging to the law enforcement, and as we move closer to implementation, we'll be sure to provide all of that information to you. So not only are we looking at information being provided through the portal, but also working with inlets to get that to our state law enforcement users too. So just go to the next slide. So here is a message that comes up in sidlist.dot.gov when you go into Query Central and you do a driver query. And we're looking to add a prohibited from driving a CMV message to that report. And basically, it will let you know that, hey, this driver in front of you should not be operating because of a drug and alcohol clearinghouse violation. It's not going to provide any more information than that. It's not going to tell you what drug may have been used or anything. It's just going to say that this driver is prohibited. And we're not even sure if this is going to be the message. It might just say prohibited from driving a CMV. We want to be sensitive to our drivers, making sure that their privacy is taken into account when we are providing information at the roadside. So this is a sample driver prohibition message. We're not sure how it's going to look once we implement it, but we will be sure to keep you posted. We plan to do an inspection bulletin, and once that is done, we'll all hopefully be operating consistently and uniformly across the country, and you all will know what you need to do with this driver if you see this message. So this is just a high-level concept, and it is something that we're working on now. So somebody asked the question, so when is this going to be available to the motor carrier? But before we get to that, let's just talk about some of the things that are going on here shortly. If you were in Colorado, at the Western Service Center's CMV CDL Safety Summit. That first block there, it said December. Because of the shutdown, we had to move the implementation back for the communications website. We're supposed to be launching that in February, but we'll see how we're supposed to be launching it in February, but I have March here. We're hoping to have it done by the end of February, but definitely by the end of March. So there you could go to that website. You can find out the status of the clearinghouse. You could sign up for alerts, and we're going to encourage people to go to this communications website to get up-to-date information about the clearinghouse. This is also going to be the site where the clearinghouse is going to be housed. So for those that sign up, especially for our motor carriers that are present, once you sign up for the communications, you'll know that this will be the same site that you go to register for the clearinghouse. System testing and development is continuing. In October of 2019, in a few months, we're hoping that motor carriers, the drivers, and the medical review officers and our other regulated entities will be able to register for the clearinghouse. And in January, we hope that the clearinghouse will go live, but it will only be for law enforcement, motor carriers, employees, MROs, substance abuse professionals, and the like. Your SDLAs, your part will be implemented sometime in the future. So, Chris, I will turn it over to you, I guess, to see if we have any questions.
Okay, there is a question. First one is, we need to make sure the messaging is appropriate for NLETS responses to and not just the CDLIS. Remember, very few police officers use CDLIS. CDILS is primarily used by compliance investigation officers, and we need the states to respond to NLETS that the driver is not valid in the CDL status field. So maybe it's just more of a comment there.
I take it that the person is referring to this slide where we mentioned that, the law enforcement will potentially go through the portal and use Query Central to determine the status of a driver, or they could use inlets, which is actually at the bottom. I'm not sure if you saw that, but we do plan for the Drug and Alcohol Clearinghouse to communicate with inlets so that information will get to our state law enforcement users. So I wonder if the person that asked, could you, Chris, just see if they have any other questions?
He's listening in, so if you do have any additional questions, and again, I think it was just kind of maybe a general comment that there needs just to be some good communication is what I'm hearing here. If there's additional things or comments you'd like to make, go ahead and make that comment.
Okay, so I get it. So the person understood that there's going to be communication with inlets, but they're asking to make sure that the inlet users know how to get this information out of the system. And I'll make a note of that. Great point. Okay, so entry-level driver training. That rule was published back in December of 2016, and it has a compliance date of February the 7th, 2020, which is right around the corner too. It was required by Section 32304 of MAP 21, and basically what it did, it just established the minimum training requirements for CDL drivers. So, when we use the, first the driver gets training, then they go through testing, and then they enter trucking. The training portion was the part that wasn't necessarily as established or as spelled out as the testing portion of when you're talking about our regulations. So we have nailed down the minimum entry-level training requirements for these individuals, and so the final rule sets forth those requirements. For those that do not know, an entry-level driver is an individual that has to complete the CDL skills test, and we're just talking about the skills test, not the knowledge test, for a CDL for the first time. So I hope you all are, I'm going to be reading this verbatim because I have a few check your knowledge questions on the next slide that will see if this information is coming across clear. So an entry-level driver is an individual that must complete the CDL skills test, the skills test, not the knowledge test, for the first time. You have to receive training if you upgrade your CDL. So we're talking about a person that goes from a Class B to a Class A, for example, or a Class C to a Class B. So if there's an upgrade. And also, if you want to get any one of these endorsements for the first time, so if you get your HM endorsement or your passenger endorsement or your school bus endorsement, you have to take entry-level driver training. So if an individual obtains a CLP on or after the compliance date, that individual will have to follow the ELD requirements. So on or after February the 7th of 2020, drivers will have to be trained to the minimum standards in our ELDT rule. So if you get your CLP before February the 7th, you will not be required to comply with the new ELDT rule as long as you get your CDL or your endorsement before your CLP expires. So I just want to make those points. On the next slide, I am going to show a couple of knowledge check questions. Okay, so group, it's February the 10th of 2020, and you are a driver that let your CDL expire 2 years ago. Do you need to take the ELDT training requirements? And I'll go back to the previous slide if you need to figure out where we are with that question. It's February the 10th, and you are a driver that let his or her CDL expire 2 years ago. So you let your CDL expire in 2017. Do you need to take ELDT? And that answer would be no. If you look at the definition of an entry-level driver, it states that it's a person who has, an entry-level driver is an individual that must complete the CDL skills test. We're talking about the CDL for the first time. So you let your CDL expire, and this is not the first time you're getting a CDL, so you wouldn't have to take ELDT. So I'm going to go back to our question, our second question. So you get your CLP on February the 1st, which is before the compliance date. Do you need to take ELDT? Okay, have you all thought about it? So this answer could be yes or no. We'll go back to it could be yes or no. So did you get your CDL before your CLP expired? If you did, you do not have to take ELDT. But if you didn't, you would be required to go through that training. So that was a trick question. Okay, the last question. It's February the 10th of 2020. It's actually after the compliance date. And you have been a CDL driver for 10 years. You want to start hauling HM for the first time and want an endorsement. Do you need to take ELDT? I'll give you some time to think about that. And the answer would be yes. In the fourth bullet down, it speaks to those drivers that want to obtain a HM endorsement for the first time. Yes, that individual will have to go through ELDT. So those are just a few questions to check your knowledge of the rule, and I'm going to continue with my presentation. For those that have actually read the ELDT rule, you'll know that the training requirements are divided into two different categories. It's the theory portion, we're talking about the knowledge test, and also behind the wheel segment. So it tells our training providers what they need to cover when they are delivering entry-level driver training. There are no minimum hours that a driver has to go through. There are only minimum standards, meaning minimum subjects that have to be covered. And the training provider has to provide instruction, all of the elements that are spelled out in ELDT in Part 380 of our regulations. And the driver has to have at least an 80% on the in the training to actually pass and to satisfy the requirements of the regulations. So when you look at the ELDT rule, it talks about the entry-level driver training, the requirements. It talks about it also talks about the entry-level driver training. It talks about the training curriculum that has to be delivered to the drivers. It also talks about the training provider registry. And the training provider registry will be a system just like the Clearing House and just like our national registry that houses information about drivers that have actually passed the test. The information will be in the training provider registry. Training providers will register for the registry, provide information into the system, and then that system will ultimately get to the SDLA, and the SDLA will have that information available to them, and the SDLA will be able to issue the driver's license. So FMCSA, we're considering a number of options to establish the registry, and the one that keeps coming up is a registry much like our national registry. FMCSA will require our training providers to put the successful completion of training in the registry, and then that information will be forwarded to the SDLA, just like we're working to do with the National Registry. And what I'm going to do, I would like to pause here and take any questions.
Okay, there is a question, and it is, how long will it take the FMCSA to communicate a student's information to SDLA so the student can test?
That information is still being worked out. FMCSA is still in the process of actually developing that training provider registry, but we are hopeful that that information will get to the SDLA immediately. You know, we're working out different options, whether it goes to our skills testing, our commercial skills testing information system, or if that information will go to CIDLIS. We're working all of that out, but we do anticipate that information will get to the SDLA quickly.
Okay, and then when will the TPR website be available to CDL schools?
The TPR is not effective until 2020, so it will not be up and running until then. And we're receiving a few certifications in the office. I just want to let you all know that you do not have to send those. The compliance date is not until 2020. When we get to the compliance date, that's when we'll ask you all to provide that information to the training provider registry.
Okay, and there are no other questions at this time. Oh, I take that back. How will the schools register if the TPR site isn't available?
You know what? We'll make sure that we communicate with you all as far as, registration, notification, and all of that other great stuff. It's not necessarily handled in my office. It's handled in another office, but we are in close contact and communication with each other. And a lot of this information is, unfortunately, for our participants, we're not with you all the time, but we communicate with our state driver's licensing agencies every other month, so they are up to date on this information. I would suggest that the people who are asking the question, Chris, that they continue to check back on our website.
Okay. And then when does the FMCSA expect to have the specs for the training provider system?
As soon as the TPR is up and running. I mean, not as soon as it's up and running, but as soon as it's up and running so that the specs can be developed.
Okay. And then a general comment that it needs to be up and running prior to February 7th of 2020 so that instructors can be in compliance.
Oh, absolutely. We know that.
Okay.
And if anything changes, just like with the National Registry, we had to delay that. Not saying that there's going to be a delay, but we'll make sure that you all have that information when you need it so that you're in compliance. We're not going to put you all out there like that. We'll make sure that you all have a system that you can use so that you're in compliance with the regulations.
Okay, the next question is, an SDLA does not schedule the skills test. Third-party organizations do the scheduling. Will the ELDT be hooked up to the CSTEMs?
Yes, CSTEMs. That's what I mentioned that. Yes, so CSTEMs, we're looking at CSTEMs and or CIDLIS. There are a couple of options that we have, and we've been in contact with AMVA about those communication options. So it's going to be one or the other.
Okay.
Because, we talked about an all-electronic process, so do not anticipate drivers coming into the SDLA's office and giving them a training provider certification. We don't anticipate that at all. We do see this as an electronic system where the information will flow from the training provider registry to either CIDLIS or to CSTEMs or to some other system.
Okay, and then are we asking SDLA input for data sharing from TPR?
Can the person expand on that question, please? I'm not really sure what they're asking.
As in the method of electronic sharing, which works best for the SDLA's process.
And is Carol talking about whether it's CSTEMs or CIDLIS?
Okay, so she's saying if that is the only method that the FMCSA is considering, then which is preferable?
So I'm sorry, is Carol asking if we would consider other options, and that's other functionality, and that's definitely a yes. And if she has any ideas, she can definitely email me. My information will be at the end of this presentation, and she can email me, and I can get that over to our policy office. The only two options we've heard of so far is CSTEMs and SID-less.
Okay, so that sounds like an opportunity, and I would suggest at this point in time that to have a good dialogue to understand, have a better and clearer understanding, that Carolyn just email Nikki she'll get the email at the end of the presentation here, and then hopefully you guys can get on the same page and you can clarify the question that you are asking as far as moving forward with a method for communication between different looks like different programs.
Yeah, and if it's somebody from the SDLA, they have my information, so feel free to contact me. I would love to hear your ideas. The National Registry of Certified Medical Examiners, the system has been down since December the 1st, 2017, and we are still working to get it back up. We are continuing to introduce interim functionality, and if you go on if you go on the National Registry of Certified Medical Examiners, there's a listing of enhancements that have been introduced, and I'm actually going to go over a few of those here today. There may have been others that have been introduced since I pulled this information together, but just so our participants know, we're still in the process of rebuilding the system. Work began on September the 18th of last year, and that work continues. So some of the functionality that was introduced in April, the search tool, it allows drivers to search on certified medical examiners. You can search on it by name, by area code, by zip code, by city, state. It's a great search tool for drivers if they're looking for, or motor carriers too, if you're looking for a certified medical examiner in your area. In June, everyone who has an FMCSA account, and I guess any government account, everyone has migrated to the login.gov account. That was introduced in June of 2018. Medical examiners are now able to were able to upload results of exams. That wasn't available once the system went down. In August, the medical examiners, administrative assistants, and third parties can now get accounts. So those medical examiners, administrative officers could actually, administrative assistants, can now go in and enter information on behalf of the medical examiner. They can actually upload those results of the exam for the examiner, which is a huge benefit to the medical examiners that are out there. The medical examiners, back in September, medical examiners and their administrative assistants, they can update their profiles, they can update their contact information, their employer information, and the medical examiners, administrative assistants can also register too. And as I mentioned, we're working to rebuild a new system. That work began on September the 18th, and I cannot share with you when we think that will be up, but I can say that we are continuing to work on that system so that it's functioning for everyone and at the fullest capacity. So for those that do not know, FMCSA issued a Federal Register notice that extended the compliance date for the medical examiner's certification integration final rule. It delayed compliance, and it changed the compliance date from June 2018 to June 2021. And we really do not know where we're going to be. We have to get our system up and running first to see if we are going to have enough time to provide those specifications to the SDLA so that they could do their programming, so that their system can interact with the National Registry. We're still optimistic that the system will be up soon and we'll be able to get things done by 2021, but, we'll see how things go. If anything changes, and as we've said before, if anything changes, we'll be sure to let you all know, and we'll continue to communicate with you all the status of the National Registry so that you're prepared to do any programming that you're required to do to make sure that the National Registry, the electronic submission and transmission of the driver certificates are working. And we'll probably we'll continue to talk about this during our CDL roundtables. This is really important for the SDLAs and not necessarily for everyone, but as far as the National Registry 2 rulemaking is concerned, making sure that we're getting that communication done. We'll make sure that we continue to update you on the National Registry so that you're aware when things come down the pipe. So we've always talked about the interim solution. We're going, that's still an option to our SDLA. So the interim solution is all about providing the electronic transfer of medical examiner certificate information to the SDLAs. And this will happen between the time the National Registry comes back up and the new compliance date. So say the National Registry comes back up on March 1st. So between March 1st of 2019 and June 22nd of 2021, we're still willing to provide our states an interim solution. And we talked about providing the driver examiner certificate information directly to SDLAs, either through a spreadsheet or flat file. This will allow our drivers to not necessarily visit the office. That information will come directly from the FMCSA, and you all will do your work from there. So that's still an option, but we're going to have to make sure that the National Registry comes back up first before we entertain that interim solution. And we're open to other suggestions too. And Chris, with that, I would like to pause for questions.
Right. There are no questions at this time and no hands raised, so we're good.
Not sure if you all are familiar with this, but FMCSA actually changed its diabetes standards. On September the 19th, FMCSA published a final rule, and the final rule is titled Qualifications of Drivers, Diabetes Standards. The rule is effective, or was effective, on November the 19th, and it applies to all motor carriers, drivers, and medical examiners. And the medical examiners, drivers, and motor carriers, you must comply with the new diabetes standards. The changes apply to insulin-treated diabetes mellitus individuals and grandfathered drivers. The rule does not apply to non-insulin-treated diabetes mellitus drivers. The medical certification process for our non-insulin treated individuals, that process does not change. So I'm just going to go over the changes and the revisions that were made in the rules. So for the first one listed there was a revision made to 49 CFR 391.41B3. Basically, it allows the use of, it allows insulin use for that section. And the 4 bullets that you see here, they actually outline the regulatory changes that are effective in the rules. So there's no longer a blanket prohibition from insulin use. Medical examiners are required to determine the qualifications of a driver. Not only do they determine the qualifications of the driver, they are going to set the new period that the driver is qualified. So that's up to 1 year. They are going to make that determination based on input from the treating clinician. Now, the process is going to be less burdensome for the driver. So we're saying all of this to say that the federal diabetes exemption is no longer needed. Medical examiners will no longer have to check on the medical examiner certificate, there's a box that the medical examiners check, and that box says accompanied by a waiver or an exemption for this individual. They are not going to have to check that anymore, but they will continue to check the box for seizure and vision. Under 49 CFR 391.46, it outlines a two-step process. The first thing that's going to happen is the treating clinician is going to evaluate the insulin-treated diabetes mellitus individual. And they're going to complete a form. And I'm going to show you a screenshot of the form. It's about I believe it's like a 15-page form that they have to fill out. The driver has to make sure that they take this form to the certified medical examiner within 45 days, because that form is only valid for 45 days. The certified medical examiner is going to consider the information that's in the treating clinician's assessment and determine whether to certify the driver for up to 1 year. He's going to have to use, as he does today, his or her independent judgment. So it's a two-step process. It starts with the treating clinician, and it goes to the medical examiner. And we hope that this is going to be less burdensome on the driver. So if the medical examiner determines that the driver has an unstable insulin program or that his diabetes is not properly controlled, the driver has, a couple of options. The driver can provide the blood glucose records to the treating clinician, and that information will be used for the medical examiner to make a determination, and that information will go into the medical examiner's review of the driver's records, and they'll make a qualification determination. So the next thing I'm going to show you is a couple of screenshots of the insulin-treated diabetes mellitus assessment form, just so you could get an idea of what the treating clinician has to complete and provide to the driver for the driver to provide to the medical examiner. So they're going to have to complete identifying information on the driver, and then they have questions that they ask, that they answer on behalf of the driver. And the thing about it, as I mentioned, this is about I want to say, if I recall correctly, about a 15-page document. It's a long document that really assesses the driver's glucose history. So as I mentioned, the form is going to become a part of the medical examination report, and it has to be maintained or retained by the medical examiner for 3 years. The purpose of this segment of the presentation is just to alert you all to the fact that we have new standards. They're a little different. Drivers no longer have to go through the exemption process, having their names published in the Federal Register notice. They just have to make sure that they have an assessment done by a treating clinician, and that information is provided to the medical examiner, and the medical examiner makes a qualification determination based on that. Any questions?
There is one question here, and is there ongoing training for the CMEs on the new process for completing the medical examiner certificate with regard to not marking the accompanied by portion for ITDM individuals? I've seen several November 1918 that were not marked correctly.
Okay, well, thank you for that information. And especially, I mean, our SDLAs, you all know this, we communicate with the medical examiners all the time, so I will be sure to pass that information along so that they are aware. So our medical programs division is aware, and they will get that information to the medical examiners. And if you all see any other issues that have sprung up as a result of the diabetes standards final rule, please let us know so we can work with the medical examiner so you all are not faced with having to make a decision about an incorrectly filled out form. So thank you all for that. Any other questions?
Just a comment on the MCSA 5870 form is 4 pages.
Oh, 4 pages. Thank you. I don't know why I thought it was longer. When I was reading it, I was thinking, oh my goodness, this is a long form, but I guess it's not that long. Thank you for that.
You're welcome. And there are no other questions at this time.
So 2 more topics. We're going to talk about the custom harvesters exemption and the employer notification system. Last 2 topics of the day. For those that are aware, we granted an exemption to U.S. custom harvesters. We published a notice on October the 5th of 2018, and basically it just re-emphasized that drivers under the age of 21 that operate in interstate commerce with a K restriction are exempt from the intrastate standard. So basically that's what that was what the U.S. Custom Harvesters exemption was all about. Hey, these drivers can operate in interstate commerce with the K restriction, even though that was always the case. But they were being pulled over by law enforcement who looked at the license and said, hey, you have a K restriction and you shouldn't be in my state. So this was a way to give our drivers some relief so that they give them some relief so they weren't being, placed out of service or what have you for operating in interstate commerce with a K restriction. No special action is required by the SDLA. There's no special requirements required by drivers. We do ask that our law enforcement so you're going to be you may be faced with a driver that has a K restriction that is operating in another state. So what we ask is that you review a copy of the Federal Register notice and the exemption notice. Actually, the driver should be operating with those. They'll provide that to you. And within the Federal Register notice, there are a list of elements that you can verify whether a driver is actually operating as a custom harvester. So in the Federal Register notice, it talks about they should have some custom harvesting paperwork. They may have the equipment, because custom harvesting equipment is, you would know it if you see it. It's pretty obvious if they have this equipment that they're actually operating under their custom harvester, under custom harvesting operations. So I just wanted to go over a couple of questions that we have put out. So what is a custom harvester? A custom harvester is actually a company or someone that harvests crops for an individual farm or business. So for a farmer that has acreage and they have a lot of, say they harvest wheat or grow wheat, the custom harvester actually comes in and harvests the wheat for them. So that will eliminate, in some instances, a farmer from having to buy this expensive equipment to do the harvesting, or if they just don't feel like doing the harvesting, they could hire out the harvesting to a custom harvester. What is the purpose of the exemption notice? Basically, it's to reduce the likelihood that these 18, 19, and 20-year-olds will be cited during inspection if they are found operating in a different state with the K restriction. So that's really the purpose of the Federal Register notice. How long is the exemption effective? The exemption is effective until, I believe, 2023. So October the 3rd, 2023. So what does this mean for the driver? Basically, the drivers will continue to do what they do today, but as I mentioned, it will definitely reduce the likelihood that they will be cited for operating in interstate commerce when they have a K restriction on their license. What does this mean for law enforcement? I already mentioned. We would like you to look at the elements that are outlined in the Federal Register notice to determine if the driver, although they have a copy of the Federal Register notice and a copy of the exemption letter, that they're actually operating within the custom harvester. Actually, they're working for a custom harvester, and all the information is spelled out in the Federal Register notice. And what does this mean to our SDLAs? Doesn't mean anything. You're not required to do any additional processing. You'll still issue a license to these drivers with a K restriction on it. So it makes it easy for everyone. The only people that are going to be put out just a little bit are our law enforcement. They'll be required to become familiar with the Federal Register notice and to be on the lookout for the operations and making sure that the driver is operating under the custom harvester exemption. And so any questions about the custom harvester's exemption?
There are no questions at this time.
And the last topic I'm going to cover today is the employer notification system. An employer notification system is a program that actually automatically sends updates to the motor carrier when one of its driver's license status changes. You could be alerted if there's a crash or if there's a conviction posted to the driver's record. So the use of these services, and particularly those with push notifications, actually satisfy FMCSA's requirement for a motor carrier to make an inquiry into each driver's record on a yearly basis. We have 18 states that have an ENS or something like it, and it's just based on the survey that we did with our SDLAs. We have provided a listing of those states and the systems that they use on our website. So if you go on our website and search Employer Notification System, you'll see a list of those SDLAs that provide the service. So for our motor carriers that are on the phone with us today, you can actually sign up with your SDLA, if you haven't done so already, to receive notifications about your driver's license status. Now, we talked about the 18 states that have an ENS or some other system. We talked about that push system. There are actually some states, and there are two that we are aware of, that allow you to go on their website, put in a driver's license number, and you'll get that status back. And you could do that at any time. These states are, I guess, referred to as a pull state and not necessarily one of those states that provide push notifications to the motor carriers. But, they all accomplish the same goal. You'll still get information about your driver's license, about your licensed drivers on a, as needed basis or on a regular basis. So those systems are available to you for our motor carriers. In 2018, FMCSA, we actually set aside $10 million to a grant funding for our SDLAs to build an ENS system, and we actually received 3 requests totaling $375,000. So for those 3 states that applied for the funding, they received it, and they're going to use the system, that money to either enhance the systems that they currently have or build a system that they didn't have before. If you look on our website, we also have a document that talks about the best practices. If you are building an ENS, these are the things that you need to consider. What kind of information you're going to provide to the motor carrier, how often, do you want to notify the motor carrier when a driver's, address change? I mean, is that important to the motor carrier? So those are some of the things that the motor carrier can work with their SDLA to get information on. And as I mentioned, this information is on our website, and all you have to do is search Employer Notification System, and you'll see the best practice there, the best practice guide there, and you'll also see the list of states that provide an ENS. And then there's other information there too. But for those that are interested, if you didn't know that your SDLA provided this information, it might be a good idea to, reach out to them to see how they could provide you this information so you can monitor your drivers. And with that, I want to provide the contact information. So if you want to know more about the Under 21 CDL pilot program, please feel free to email us at under21pilot@dot.gov. And this presentation is going to be provided to you, so you'll have this information handy. If you have any questions, Drug and Alcohol Clearing House has its own separate email address. If you want to, if you have questions about ELDT, the Custom Harvesters, or ENS, you contact the division at CDL Compliance at dot.gov, or if you have any questions about the National Registry or the Diabetes Federal Register notice, you could contact our Medical Programs Division. And as I promised, my contact information is here. If you have any questions, or if you want to follow up on something I may have said today, feel free to contact me.
Great. I think you did a wonderful job, Nikki. You obviously provided lots of great information, and thanks again for your presentation today. For those interested, I just posted the link to access the presentation slides that's in the Q&A box there on our Commercial Vehicle Safety Center website, and I believe Chris has also posted it earlier as well. As I mentioned at the beginning of this webinar, this is the first in a series of webinars as part of our Commercial Vehicle Safety Center, and we'll be sending out the announcement for our next webinar soon. In addition, another goal of our center is to provide resources and assistance to help establish partnerships between agencies, industry, universities. So if you're interested in forming a partnership or would like any more information, please reference our website or feel free to contact me directly. Thanks again for your attendance today, and if there are no further questions, I will turn it over to Chris to close the session.
Awesome. Thank you both very much. Thank you, Nikki, for sharing your expertise and sharing this information. Not being in my subject matter area, learned a lot. There's a lot of changes and a lot of things happening, and I see a lot of potential and opportunity for working together and collaborating with the different partners out there. So thank you for sharing that. So with that, I'm going to go ahead and close today's session.